Thank you, Mr President. I begin my contribution today by acknowledging the Palawa Pakana of Lutruwita, Tasmania, the Tasmanian Aboriginal community. I pay my respects to their elders, past, present and emerging. I acknowledge the enduring connection of the Palawa to this land which was never ceded, a connection that has survived invasion, dispossession, colonial violence and continued discrimination. And I make this acknowledgement because of the particular relevance of the motion we're debating today to the First Nations people of this state and this country. Nationally, Aboriginal and Torres Strait Islander young people aged 10 to 17 years are vastly overrepresented in youth detention facilities. According to analysis by the Victorian Sentencing Advisory Council published this year, Indigenous young people are 6 times more likely to be detained in Tasmania than non-Indigenous young people. Remarkably and sadly, this is the smallest difference in detention rates between Indigenous and non-Indigenous young people of any state and territory, but I don't believe that is a distinction that we can feel proud of here. Nationally, Aboriginal and Torres Strait Islander children are overrepresented in the youngest age groups in particular. Across the country, on an average day in 2018-19, 65% of children aged between 10 and 13 years who were under youth justice supervision were Aboriginal and Torres Strait Islander. 65%. Mr President, while Tasmania rates comparatively well on a national level in the disparity in detention rates between Indigenous and non-Indigenous youth, I think we can all agree that any level of disparity is unacceptable. Mr President, our current minimum age of criminal responsibility and the system of youth justice, including incarceration that sits around that, is not just discriminatory. It is failing. It's failing on every measure. It's failing the young people who encounter it, who are more likely to have experienced disadvantage, abuse, mental and physical ill health, disability, developmental delays, disengagement from education, precarious housing and contact with the child safety system. We know that rather than recognise and meet their needs for support and assistance, the youth justice system sets them instead on a path where they are more likely to reoffend and compound the difficulties that they face. But it's also failing our community, where rather than making us safer, more cohesive and resilient, the current ineffective youth justice system puts us more at risk and contributes to a community that is more divided. When we look at the current minimum age of criminal responsibility and the youth justice system that sits around it, what is clear is that it is neither smart nor compassionate. Just as all laws are updated from time to time to reflect the developing views and expectations of the community and the increasing understanding and evidence base of good policy, it's timely for us to be considering an increase to the minimum age of criminal responsibility in this state. Mr President, the motion we debate today should not be viewed in isolation. Right across the country, the momentum for raising the age of criminal responsibility is building, and members have a chance today in this place to not only be part of that momentum, but to shift it into a higher gear here in our state of Tasmania. In December 2019, the Council of Attorneys General called for submissions on whether to raise the minimum age and what an alternative system for managing youth justice would look like. They received submissions from organisations such as Amnesty International Australia, National Legal Aid, the Aboriginal Justice Caucus, the Australian Medical Association, the Australian Youth Affairs Coalition, the Council for Social Services, the Murdoch Children's Research Institute, the Australian Red Cross, the Royal Australasian College of Physicians, the Royal Australian and New Zealand College of Psychiatrists, Save the Children and the Youth Network of Tasmania. These are organisations whose expertise spans human rights, the law, physical and mental health, Indigenous justice and youth services. All of these recommended raising the age of criminal responsibility from its current level of 10 years. Mr President, National Legal Aid in its submission helpfully provided some context for how society recognises the physical and cognitive and emotional vulnerabilities of children under the age of 14 years. Their submission highlighted that children under 13 years old cannot register as Facebook users. Qantas considers children under 12 years old as unaccompanied minors. An average 10-year-old requires a booster seat to travel safely in a car. And in some Australian jurisdictions, it's a criminal offence for a parent or guardian to leave a 12-year-old alone and unaccompanied. And yet, across Australia, 10-year-old children can be arrested and detained in custody for alleged criminal offences. Mr President, it seems incredible that we are perhaps more careful about who we sit an 11-year-old next to on a plane than we are with what we might expose them to, the same 11-year-old, in our youth justice system. This is not just an issue that has momentum in Tasmania or nationally. It is an issue that has international attention. In 2019, the United Nations Committee on the Rights of the Child, the UN Committee I'm going to call it, recommended that all UN member states raise the minimum age of criminal responsibility to at least 14 years of age. In its observations on Australia, the UN Committee noted, with serious concern, the very low minimum age of criminal responsibility in all states and territories, and recommended that Australia raise the minimum age to reflect internationally accepted standards to the upper age of 14 years. In its general comment number 24, 2019, on children's rights in the child justice system, the UN Committee on the Rights of the Child noted that under Article 43 of the Convention, states parties are required to establish a minimum age of criminal responsibility, but the article does not specify the age. Over 50 state parties have raised the minimum age following ratification of the Convention, and the most common minimum age of criminal responsibility internationally is 14. It's worth noting, Mr President, at this point that the age of 14 has not always been the internationally recognised standard. In 2007, the UN Committee's last general comment on this matter, it stated that a minimum age of criminal responsibility below the age of 12 years is considered by the committee not to be internationally acceptable. In 2019, however, it revised that age to 14 years based on documented evidence in the fields of child development and neuroscience, which indicates clearly that maturity, and I quote this, that maturity and the capacity for abstract reasoning is still evolving in children aged 12 to 13 years due to the fact that their frontal cortex is still developing. This is a good example of responding to the improvement of our understanding based on evidence and reflecting community views and expectations. The UN Committee noted that children under age 14 are therefore unlikely to understand the impact of their actions or to comprehend criminal proceedings fully. Not only has this been recognised by the United Nations, but by many of the stakeholders who have engaged with this issue, from social workers to lawyers to former magistrates to youth services. The UN General Comment went on to recognise that these children are also affected by their entry into adolescence. As the committee notes in its General Comment number 20 from 2016, which is on the implementation of the rights of the child during adolescence. Adolescence is a unique defining stage of human development. It's characterised by rapid brain development, and this affects risk-taking, certain kinds of decision-making, and the ability to control impulses. In January of this year, the Australian Government appeared before the UN Human Rights Council in Geneva for its major human rights review that happens every 4 to 5 years. At this review, known as the Universal Periodic Review, the UN member states questioned Australia about its human rights record and recommended improvements. 122 countries made close to 250 recommendations to us. One of the key issues of concern raised in that forum was the very low age of criminal responsibility in Australia. 31 countries recommended that Australia raise the age to at least 14. These recommendations came from countries including Italy, Venezuela, Slovakia, Spain, Sri Lanka, Mexico, Canada, Denmark, France and Germany. These criticisms of Australia's record on this issue are nothing new. In its concluding observations on the combined 5th and 6th periodic reports of Australia in 2019, the Committee on the Rights of the Child urged Australia to raise the minimum age of criminal responsibility to an internationally accepted level and to make it conform with the upper age of 14 years. In 2017, the UN Human Rights Committee stated that it remained concerned that the age of criminal responsibility for Commonwealth, state and territory offences is 10 years and that the state party should raise the minimum age of criminal responsibility in accordance with international standards. So too did the Committee on the Elimination of Racial Discrimination. These are resounding calls. And furthermore, the United Nations Special Rapporteur on the Rights of Indigenous People published a report in her 2017 visit to Australia and noted the application of criminal responsibility as low as the age of 10 years across the country is deeply troubling and below international standards. And further, that it is wholly inappropriate to detain children in punitive rather than rehabilitative conditions. Aboriginal and Torres Strait Islander children are essentially being punished for being poor, and in most cases, prison will only perpetuate the cycle of violence, intergenerational trauma, poverty and crime. Mr President, to put Australia's minimum age in an international context, we can look to the age of criminal responsibility in other national jurisdictions. The global median age of criminal responsibility is 14. In Angola, for example, the minimum age of criminal responsibility is 14. The minimum and maximum sentences for those between ages 14 and 16 are reduced by 2/3. And for those between halved for those between 16 and 18. So there's a sliding scale there that applies through to the age of majority, 18. The needs of rehabilitation and social reintegration are also to be taken into account for anyone under the age of 18 in that jurisdiction. In Belarus, the standard age of criminal responsibility is 16. But for those between the age of 14 and 16, they can be held responsible for select serious crimes, as outlined in a particular part of their criminal code. The age is 14 years or higher in Georgia, in Germany, Japan, Vietnam, Colombia and the Democratic Republic of Congo. These are just some examples. Hugh de Kretzer, the Executive Director of the Australian Human Rights Law Centre, observed that Australia's human rights record that is plagued by human rights failures, and particularly by its treatment of Aboriginal and Torres Strait Islander peoples. As a wealthy, stable democracy, Australia should be leading the world on human rights, yet too often Australian governments breach people's rights in critical areas. This must be linked to the appalling rates of incarceration we see in our First Nations people. Mr President, as stated by the UN Committee on the Rights of the Child, the medical and scientific evidence on the neurodevelopment supports the claim to raise the age of criminal responsibility. Numerous Australian medical organisations have supported raising the age to at least 14, with their views rooted firmly in scientific research. These include the Royal Australian and New Zealand College of Psychiatrists, the Australian Medical Association, the Royal Australian College of Physicians and the Public Health Association of Australia. The science is clear. Neurodevelopmental evidence demonstrates that the period of adolescence brings increased impulsivity and sensation-seeking behaviour, coupled with a heightened vulnerability to peer influence, which affects decision-making capacity. The frontal lobe of the brain that plays a key part in various elements of cognition, including judgment, empathy, consequential thinking, the inhibition of impulses and coherent planning, continues to be developing physically until a person enters their early 20s. This means the frontal lobe is significantly underdeveloped when a child is in adolescence, particularly early adolescence. Children under the age of 14 are also limited in their capacity for abstract reasoning, which means they're unlikely to comprehend the true impact of their actions or of criminal proceedings. The Royal Australian College of Physicians has stated that a range of problematic behaviours in 10 to 13-year-old aged children that are currently criminal under existing Australian law are better understood as behaviours within the expected range in a typical neurodevelopment of a 10 to 13-year-old with significant trauma histories. Typically actions that reflect poor impulse control, poorly developed capacity to plan and foresee consequences, such as minor shoplifting or accepting transport in a stolen vehicle. Mr President, given the high rate of neurodevelopmental delay experienced by children in juvenile detention, including conditions such as fetal alcohol spectrum disorder, FASD, and delayed language development, the Royal Australian College of Physicians submitted that these behaviours often reflect the developmental age of the child, which may be several years below their chronological age. Judging criminal responsibility on the basis of a chronological age is therefore inappropriate for children who may have a much lower developmental age due to a number of medical and developmental conditions described. Similarly, there's also significant evidence that a large proportion of young people in the criminal justice system have significant health issues, including mental health issues, disability, including FASD as mentioned, substance misuse, sexual health, including STIs, and trauma. Young people who enter the justice system are more likely to be affected by disabilities and poor mental health and wellbeing. Youth justice supervision and detention exacerbate these challenges that the young people and children face. A recent study by the Australian Institute of Health and Welfare found that 75% of young people involved in the justice system had experienced some form of non-sexual abuse, including physical, verbal, emotional, financial or neglect. Compared with their peers in the general community, justice-involved young people were 6 times as likely to have attempted suicide, more than twice as likely to have recently self-harmed, and twice as likely to experience high or very high psychological distress. A third of the young people involved in the justice system met the criteria for at least 2 mental health disorders. These are not conditions that are best dealt with in prisons. These are not members of our community that are best helped by the justice system, Mr President.
Through you, Mr President. Sorry, when you talked about, you said 6 times.
Yes.
The
6 times as likely to have attempted suicide.
If they're incarcerated.
So yes, justice-involved young people. So young people who've got an involvement with the justice system.
That clear. Thank you. Sorry to interrupt your flow.
It's okay. Mr President, additionally to this, it has been proven that incarceration of young people may systematically degrade their healthy development further. Cumulative incarceration duration during adolescence and early adulthood is independently associated with worse physical and mental health later in adulthood, including functional limitations, depressive symptoms and suicidal thoughts. Thank you. Expert witnesses at the 2016 Royal Commission into the Protection and Detention of Children in the Northern Territory directly linked experiences of youth detention with subsequent violent offending and with the cycle of repeat incarceration setting young people up to fail. As was submitted by the Public Health Association of Australia, and I quote, "Despite the high level of need for mental health services, few young people involved with the justice system access these services in the community. There is a clear need for holistic, trauma-informed social and healthcare interventions for these young people, with priority given to preventing, identifying and intervening to reduce abuse." Not only is the current system not helping the children, nor is it helping society more broadly. Studies have shown that the younger children are, when they encounter the justice system, the more likely they are to reoffend. We set them on the path. The Australian Institute of Health and Welfare identified that children who were first subject to supervision under the youth justice system due to offending who were between the ages of 12 and 14 were more likely to experience all types of supervision later in their teens. 33% compared to 8% of those who first became involved at older ages. Mr President, there's no doubt that this issue affects Aboriginal and Torres Strait Islander children and young people more than anyone else. Indigenous children are vastly overrepresented, as I said, in the justice systems of all jurisdictions in Australia, and a very important step to addressing this is raising the age of criminal responsibility. The Australian Medical Association notes this, that around 600 children below the age of 14 are locked away in youth jails each year, nationwide, with Aboriginal and Torres Strait Islander children constituting 70% of this cohort. They also note that around 9,000 children below the age of 14 have contact with the broader criminal justice system each year, and that overall Aboriginal and Torres Strait Islander children constitute around 5% of the youth population, yet close to 60% of children in prisons. The National Aboriginal and Torres Strait Islander Legal Service, NATSIL, in their submission to the Council of Attorneys General Age of Criminal Responsibility Working Group review, stated that a higher minimum age could also prevent children and young people, particularly Aboriginal and Torres Strait Islander children and young people, from being trapped in the quicksand of the criminal justice system. And I think that's a really appropriate metaphor, the quicksand. It's very hard to get out once you're in. NatSil also suggested that a trauma-informed approach to the minimum age of criminal responsibility is particularly important for children and young people. NatSil suggests that this is a critical factor that must be considered when discussing raising the age, as Aboriginal and Torres Strait Islander children and young people are particularly more likely to experience early trauma than their non-Indigenous peers. Locally, Rodney Dillon is a Palawa elder and Amnesty International's Indigenous Rights Advisor. He has called for Indigenous and community-led solutions, stating that this is all about the kids. I don't want to see one set of 10-year-old eyes in a prison system. It really hurts me to see that when those kids could be doing better somewhere else. As an Aboriginal person, I've seen all my life people go into that system and never come out of it. And I could have been one of those kids. That's powerful, Mr. President. NatSil, in their submission, stated the importance of Indigenous children's connection to country, to land, family, community and spirit. They emphasised that children flourish particularly when they have and are allowed to develop strong and positive social networks and have strong leadership in their families and communities. Members of the stolen generation and their children are particularly more likely to be forced into or experience poor physical and mental health outcomes, inadequate housing, substance abuse, lower incomes, over-policing and therefore over-incarceration. In 2012-13, almost half of all Aboriginal and Torres Strait Islander adults reported that they or their relatives had been removed from their natural family. Because of these entrenched and systemic disadvantages, some Aboriginal and Torres Strait Islander children can be trapped in cycles of trauma, poverty, injustice and illness at key times of their neurological development. These further compound and entrench their disadvantage. I was particularly struck by another comment from Rodney Dillon. He said this: I fear that there are a lot of kids that have gone into that system that would have made great leaders in their communities. That's a comment that goes to the heart of this issue, Mr. President. Children embody potential. How we support and educate, love and protect them will determine whether that potential has the opportunity to be realised. Mr. President, I'd like to mention some matters now in relation to this motion that come up and are raised at times in the discussions on the proposal to raise the minimum age of criminal responsibility. Currently, when a child between the ages of 10 and 14 is charged with a criminal offence, what occurs in response is governed by the common law legal principle known as Dolly Incapax. I'm probably saying that incorrectly, and I'm going to keep saying it incorrectly, but we'll all cope. This is the presumption that children under the age of 14 cannot be held criminally responsible for an offence unless it's proven that they knew what they were doing was seriously wrong. The principle of Dolly Incapax is often raised as an argument against raising the age of criminal responsibility. However, there are so many practical problems with the current application of that principle in Australia that render it giving very little or no protection to those children that need it most. As emphasised by Youth Law Australia, the Human Rights Law Centre and the Law Council of Australia, the evidence of Dolly Incapax's application in Australia highlights concerns with evidentiary issues. They point to it leading to the admission of evidence that would commonly otherwise be inadmissible, to an unofficial reverse onus of proof, to inconsistent application and a lack of coherency of the principle, which can lead to the prolonged involvement of children in the criminal justice system. There are practical difficulties in proving whether a child knew that a certain act was wrong under Dolly Incapax. Reports have shown that in attempting to rebut the presumption, the prosecution is often allowed considerable evidentiary concessions and prejudicial, normally inadmissible material is deemed to be admissible. The UN Committee on the Rights of the Child observed that the presumption of Dolly Incapax can lead to children being treated differently based on evidence brought to rebut the presumption, which might not necessarily require evidence from an expert like a psychologist. As Youth Law Australia observed, the evidence that is commonly used fails to take into account the interaction between a child's developmental maturity and the conditions in which an offence occurs. Furthermore, contrary to the key element of the presumption that the onus of proof lies on the prosecution, in practice, the principle is applied inconsistently, which can lead to an unofficial reversal of the onus of proof. According to recent research with legal stakeholders in Victoria, the onus commonly fell on the defence to provide, a report at their own cost to establish that the child is dolly incapax. Stakeholders in this research also indicated that children may refuse an assessment without full comprehension of the consequences of that decision, and this could lead to the wrongful conviction of children. Mr President, the presumption has also been criticised on the basis that it prolongs a child's involvement with the criminal justice system due to a lack of coherency over how the presumption operates, leading to children being held in custody for lengthy periods before the presumption is led or tested in court and the child acquitted. The trial to determine capacity and guilt could take months or longer, depending on court lists, case management processes or the availability of experts and other witnesses relevant to the proof of knowledge and maturity. As there is significant research demonstrating the negative psychological effects experienced by children in custody, this prolonged involvement with the system is troubling. The vast majority of submissions to the National Working Group recommended abolishing the flawed presumption of dolly incapax on the basis that it does not work in practice, and instead to use the effective measure of raising the age to at least 14. Mr President, the issue of raising the age of criminal responsibility in Australia has been discussed for some years. The Tasmanian Attorney-General, Elise Archer, has repeatedly stated that she wants to see a nationally consistent position on any reform in this area. The Council of Attorneys-General initiated the working group on the minimum age of criminal responsibility in November 2018. But 3 years later, here we are, and we are yet to have reached a nationally agreed way forward. On the 27th of July 2020, the then Council of Attorneys-General was presented with a report from the Minimum Age of Criminal Responsibility Working Group's public consultation, comprising submissions, and I mentioned some of these already, from 88 bodies, legal, Indigenous, human rights, social service organisations. That report about those submissions overwhelmingly recommended that the age of criminal responsibility be raised to at least 14. And yet the Council of Attorneys-General postponed a decision on raising the age last July, and since a change to the Council's operating structure now means it will only convene as necessary to discuss up to 3 items of national importance over a 12-month timeframe. And guess what? Raising the age is not on this year's agenda. So we're going to push it down the road even further if what we're waiting for is a national approach. In a statement, the Federal Attorney-General's Department said that the minimum age of criminal responsibility is primarily an issue for states and territories, as the overwhelming majority of offences involving children are state and territory, not Commonwealth offences, and that ultimately it will be a decision for each jurisdiction whether to raise the minimum age. Mr President, it is clear that left up to the Federal Attorney-General or the Council of Attorneys-General, this much-needed reform will not take place in the foreseeable future. And it doesn't need to wait for action at that level. It is both right and appropriate that the states and territories take this matter into their own hands, rather than allow continued bureaucratic delays at a national level to hold us back from a reform which is both smart, compassionate and also timely. This has already begun to happen, Mr President, in other jurisdictions, with the ACT government passing a motion to raise the age to 14. In July, a discussion paper was released by the ACT Attorney-General to help steer the government's approach to the complex legal and systematic questions that lay at the heart of implementing this issue. On the 10th of October, an independent review commissioned by the ACT government was released, detailing the work and the reforms that would be needed to assist in raising the age, with the new legislation being planned to be introduced in the Territory in 2022. It's an excellent report that was released just this year. The report assessed the current service system and identified the changes that would be necessary to better meet the needs of children most affected by raising the age. It's a very valuable resource and provides what is virtually a roadmap that could and should be used to help other jurisdictions, including Tasmania, to make progress on this issue. What this also illustrates, Mr President, is that this is that the commitment by a state or territory government to raising the age is the starting point for a careful process to plan for its implementation. We need to be very clear that this is not a case of simply raising the age out of the blue one day and leaving it at that. A commitment is the starting point. A decision on the policy is the first step. And then we look to the how of how we replace an inappropriate and ineffective system with an evidence-based, an appropriate and cohesive system. Mr President, recently we've also seen traction on this issue in Western Australia, with the Western Australian Labor Party passing a motion at their state conference committing to raising the age. With that party holding 53 of 59 seats in the West Australian Legislative Assembly and 22 of the 36 seats in their Legislative Council, it's highly likely that this reform will be legislated there in the near future. And yet Tasmania has a chance here to be the first state to pass a parliamentary motion of support for raising the age and to be a nation leader in this much-needed reform. Rather than waiting for an unnecessary national approach, it's important and perhaps more appropriate it's for Tasmania to make our reforms on this issue a leadership issue nationally. Each state and territory in Australia has its own youth justice legislation, policies and practices. It is up to us, therefore, to decide what happens in this state on this issue. It's also important, Mr President, to note that historically there has not always been uniformity when it came to the minimum age of criminal responsibility. It isn't a precondition for us to make this change that everybody else does it at the same time or lands in the same place that we do. It took around 24 years for the Australian governments to achieve the present uniform minimum age of 10 years in all Australian jurisdictions, with Queensland first raising the age from 7 to 10 years in 1976 and Tasmania being the final jurisdiction to raise the age from 7 to 10 years in 2000, 24 years later. That time, we were the last out of the blocks, Mr President. This time, we have the opportunity to be the first out of the blocks as a state to make this change. The Tasmanian government has the opportunity to grasp this position, this positive opportunity to grasp this position and step out from behind unnecessary delays that are occurring at a national level. It would be very poor indeed. It would be a threadbare excuse that inaction at a national level should see us continuing to fail Tasmanian children and communities in delivering a more effective youth justice response in this state. Rather, I think the government can have confidence in taking leadership action on this issue. There is a great deal of support in the Tasmanian community for raising the age of criminal responsibility. Just yesterday, Amnesty released a statement of support which was signed by around 50 prominent Tasmanians. Mr President, I would like to read that statement into the record today and mention some of the signatories to show the breadth and depth of support for this positive reform. This is the statement of support to raise the age of criminal responsibility in Tasmania. And it says, "We, the undersigned, call upon the Tasmanian Government and the Parliament of Tasmania to take urgent action to raise the minimum age of criminal responsibility in Tasmania to at least 14 years of age. Major Australian organisations representing the medical, mental health, child welfare and legal professions, as well as human rights bodies and organisations representing Aboriginal and Torres Strait Islander people, agree that the current minimum age of criminal responsibility, 10 years of age, is far too low. The scientific evidence is overwhelming that at the age of 10 a child's brain is still developing, particularly in terms of reasoning skills, impulsivity and consequential thinking. The evidence also shows that many children who become involved in the criminal justice system come from disadvantaged backgrounds and have complex needs that are better addressed outside the criminal justice system through a developmentally appropriate, trauma-informed and culturally safe early intervention model that supports children in their families and communities. Furthermore, there is also strong evidence that the younger children are when they first encounter the youth justice system, the more likely they are to reoffend. Finally, the numbers show that the criminalisation of children in Australia overwhelmingly affects Aboriginal and Torres Strait Islander children. The UN Convention on the Rights of the Child, in force in virtually all countries in the world, states that the best interests of the child must be the primary consideration in all actions concerning children. We note that this issue has been under discussion nationally, but after 3 years, Attorneys General of the states and territories have not been able to agree on a way forward. There is no reason for Tasmania to wait for national consensus, and indeed the Federal Attorney-General has stated that ultimately it will be a decision for each jurisdiction whether to raise the minimum age. This is an opportunity for Tasmania to show a better way of treating kids, a model based on programs and services that address the underlying causes of their behaviour, including programs for Aboriginal youth led by Indigenous people. Tasmania should act swiftly to raise the age of criminal responsibility, and we commit ourselves to support this process in whatever way we can. Mr President, what a wonderful resounding statement that is, especially that commitment to support the process in whatever way. And let me mention some of the signatories to this letter. I'll table it so that the full set of signatories can be put on the record. But just to mention, Professor David Adams, the Professor of Management at UTAS, Professor Nicole Asquith, who's the Director of the Tasmanian Institute of Law Enforcement Studies, Yvette Seatle, CEO of Women's Legal Service Tasmania, Rodney Croom from Equality Tasmania and the 2015 Tasmanian of the Year, Kristen Desmond, founder of Tasmanian Disability Education Reform Lobby and chair of Children and Young People with Disabilities Australia, Connie DeGolis, CEO of the Mental Health Council, Rodney Dillon from Amnesty as Human Rights, Indigenous Rights Advisor, Saul Eslake, independent economist, Matthew Evans and Sadie Chesterman from Fat Pig Farm. We've got Simon Gates, President of the Law Society, the Honourable Lara Giddings, former Premier and Attorney-General of Tasmania. We've got Michael Hill, the Chief Magistrate of former Chief Magistrate of Tasmania and former Acting Justice of the Supreme Court of Tasmania, and he's also the Chair of the Just Desserts Drug Court Support Group. Tanya Hunt, CEO of Why Not? Rosalie Martin, founder of Connect 42 and 2017 Tasmanian of the Year. Leanne McLean, Commissioner for Children and Young People in Tasmania. Scott Rankin, Creative Director and CEO of Big Heart and 2018 Tasmanian of the Year. We've got Councillor Anna Reynolds, the Lord Mayor of Hobart. Grace Tame, 2021 Australian of the Year. Rob White, Distinguished Professor of Criminology, School of Social Sciences at UTAS. Thurza White, General Secretary of the CPSU. And I'll finally mention the Honourable Jim Wilkinson, former President of the Tasmanian Legislative Council and President of the Tasmanian Football Board. That's just some of the signatories, but it gives you a flavour of the breadth of people who support this move. I was particularly impressed with that collection of former Tasmanians of the Year. Almost got a set, I think. Can we perhaps table that? Can I move to table that? Seek leave to table?
The honourable member for Nelson seeks leave. The question is leave granted? Those of that opinion say aye. Aye. To the contrary, no. I think the ayes have it.
Thank you, Mr President. In addition to those prominent Tasmanians who are signatories to that statement, we know that there are many everyday Tasmanians, mothers, fathers, brothers, sisters, teachers, elders, who do not want to see 10-year-old children locked up. I would particularly like to acknowledge the work of Amnesty in this space and the work of local volunteers here in Tasmania, in particular Sylvia Merope, the convener of Amnesty Southern. Sylvia and the Amnesty team have been strong and persistent advocates on this issue. In its submission to the Council of Attorneys General Age of Criminal Responsibility Working Group review, Amnesty highlighted that the minimum age of criminal responsibility has been an important area for Amnesty International's research into the representation of Indigenous children in youth justice systems across Australia. In addition to recommending that the minimum age be lifted to at least 14, Amnesty in its submission further recommended that all Australian governments transition all children out of prison within a year and abolish the notion of dolly incapax. Mr President, raising the age of criminal responsibility provides an opportunity to redesign the approach our system takes to understanding and responding to harmful and troubling behaviour in children in this state. Redirecting our response to this behaviour from a criminal justice one will shift the focus from what the child might have done to what the services need to do to better support and prevent such things from happening. The discussion paper that was released by the ACT government includes many helpful areas of suggested reform. in terms of redesigning our service system to better meet this need. They talk about or suggest the creation of a multidisciplinary panel, for instance, made up of experts who can assess the needs of the children and young people and provide referrals to appropriate services to meet their needs, and work closely with the children and their families to ensure that they attend these services. Suggestions are that experts on this panel could cover areas such as medical, paediatrics, education, social work, child protection, and that this work would be done in an inclusive and cohesive way. The panel would be able to respond earlier and more effectively, and with a greater emphasis on the rights of the child than the current youth justice system ever could. That's just one model that's been looked at in that ACT paper. It is clear that further support is needed for children and young people and their families well before situations reach crisis point. These supports, like physical and mental health services, education support, disability services and counselling, and including things like stable accommodation, will go a long way to addressing the issues that result in children currently becoming involved in youth justice. With the government's recent announcement, Mr President, of the closure of Ashley Detention Centre, now is the time to start the much-needed reform of youth justice in this state. I echo Premier Peter Gutwin's words in his announcement on the 9th of September, where he spoke of the need for reform and investment in, and I quote, a contemporary, nation-leading therapeutic approach to youth justice. The first step to this reform, as has been recognised by civil society, Indigenous organisations, United Nations and other national and international jurisdictions, the first step is raising the age. In conclusion, Mr President, here we are, by chance debating this motion in National Children's Week. I hope that other members of the chamber have found it as valuable and enlightening as I have to direct our attention to this topic and to give consideration to the opportunity that we have in this state for sensible, evidence-based, compassionate reform. I know that we have all received some compelling communications from a range of advocates on this topic, and I'm sure that perhaps in some contributions from my colleagues, some of those will be made reference to or aired in the chamber. But I would like to finish by sharing an anecdote from a young lawyer who has communicated with me on this topic, which I think is illustrative of the need for reform. He told me this. As a young law graduate, I volunteered and undertook an internship with the Aboriginal Legal Service in Western Australia. There I came into contact with so many young clients, many of whom were first charged with offences at the ages of 10 or 11. In a situation that highlights the farcical nature of the current system, once at the magistrate's court, the magistrate, who was appearing via video link, told our client to stand up. He did so. Then the magistrate told him again to stand up. The magistrate had to be informed that the client was in fact standing up because he was so small that she could not tell. Mr President, children don't belong in the criminal justice system. To have them there is not smart justice. It is not compassionate justice. It does not serve our community. This motion today is a statement of encouragement from this place to the Tasmanian Government. We are at an ideal time for positive change. We have an opportunity to do better, not only for the safety and well-being of our community overall, but importantly, for those Tasmanian children who precariously teeter at a point in their already disadvantaged and too often trauma-laden lives, at a point at which they might be provided with support, growth and healing, or at which they may be criminalised and face a slippery slope to entrenched criminality and harm. Mr President, let's agree to grasp this opportunity and to put our state at the forefront of positive change. I commend the motion to the House.
The question is that the motion be agreed to. The honourable member for Murchison.
Thanks, Mr President.